here are the basic things you need to know, especially if you're acting as an entrepreneur. Really the key thing with trademarks, why do we worry about it? Well, we worry about it because it really is the most important way to protect your brand. So in other words, you're going to create a company, and no matter what kind of company you have, you're going to be trying to promote your business, and you're going to use names and images and taglines and things like that you want to then have to, let people in the world know who you are. So given all that, the only way to actually protect that legally is through trademark. And so trademark then is something that, in contrast to patents and copyrights, which operate at the federal level, trademarks operates at both state and federal level. So you can have state level trademarks as well as federal. The good news is kind of like copyrights, as Professor A-Stars was saying, that just by fixing something in a tangible medium, you have copyright, even though you have to register to enforce it, but you still have it even before you register it. Similar to that, once you start using a mark, a name, an image, a sound even, in conjunction with your brand as you sell products or services or offer them for sale, then you're starting to develop state common law rights. That's all you need to do. You just need to be able to show that you are using it in commerce, is the term that the courts and the law looks for. So in other words, the mark has to be used closely in conjunction with, on, or close to the product as you offer it in the marketplace. Some states allow you to register the mark, but for the most part, just using it in commerce will allow you to develop those state rights. Now, if you look down at the bottom of the slide, it's important that you use the TM, the superscript TM symbol, if you are developing those common law state trademark rights. Do not use the circle R, which you can only use when you've gotten a federal registration, okay? You can also use, not to complicate things too much, but you can use a superscript SM, which stands for service mark. So if you're really delivering services like accounting or music services or things like that, design services, then technically you're doing a service mark, but there's no harm if you just put the TM on there instead. Okay, so again, you want to then develop those state law rights, and you can start developing as soon as possible. And then if you feel like you're really going to start making headway and you're going to develop your products and services beyond your local geographic area, then you're going to want to try to get federal registration, because that gives you presumptive rights all across the United States. It doesn't trump, though, pre-existing rights that someone has somewhere else. So let's say you're here in the DMV area and you're developing your products or services, but somebody up in Washington State in Seattle has a product and they're using the same exact mark. You don't know that they're using that mark. You file for your federal registration. You can get your federal registration. And then it may turn out, though, that someone, again, is using it locally in the Seattle area. So you can't enforce your federal mark against them up over in that limited area. So that's something to be aware of. It doesn't give you, gives you presumptive rights across the US, but not guaranteed rights. Okay, let me click my slides here. So as I mentioned, you have trademarks and service marks. You also have certification and collective marks. Certification is something like you want to certify that something is, let's say, kosher. That's an example a lot of people know about. And so what does it mean to have a certification mark? It means that some group, organization, entity goes ahead and registers that mark, but basically it leaves it open to anyone to use if they meet those certification requirements. So you don't have to be a member of the club or anything like that. You just have to then show that you are using it to the criteria they've established for it. You meet the standards, you get to use that certification mark. Slightly different then is a collective mark, which you do need to be a member of the collective, like a dairy cooperative or something like that. If you're a member of that and that entity has registered a mark, then you get to use it. Thinking like, dairy co-op of, Maryland or something like that. I already mentioned the kind of formats are broader than you may think. So it's not just words, names, and not even just graphics, which we often think about as well, design images like the Starbucks siren or something like that, but also color. Even color standing alone in some cases can be protectable as a mark. Fragrance, in some limited circumstances, an actual smell can then be registered as a mark and used. And sound, the sound of something. Basically, one that was tried to obtain was Harley-Davidson for the distinctive sound of the motorcycle engines. Sitting right next to trademark is trade dress. And this is the shape of the container or the kind of establishment where you are delivering your products or services. So an example we often use was more back in the old days, although you still see it on the so-called Mexican Coca-Cola bottles, but Coca-Cola bottles with that distinctive curved shape, the classic Coke bottle shape, is just a classic example of trade dress. It can get its own protection. It serves as a kind of trademark type thing. You see the bottle, you believe it is going to be Coca-Cola inside that. Also things like establishments. So something like the old days, I guess, McDonald's with the golden arches. So things like that then can get trade dress protection. What's really important in all of trademarks, though, is that it's on non-functional elements. So it has to be something that is really just serving as brand recognition, design, aesthetics, not about the functional parts of the product. So if that shape of the Coca-Cola bottle made it pour faster or better or slower or whatever, then that would not have been protectable under trade dress or any kind of trademark protection. Now, let's talk about something that's really important when you're trying to decide, hey, I have this word or this image or something I'm using, and you're trying to think, okay, so I want to try to get this protected. I want to start using this. If you talk to a lawyer, a trademark lawyer, they'll take you through this level of distinctiveness to help you understand the potential strength of the trademark. And what this means is the likelihood that you can establish rights to it and then enforce those rights later on. So you see that I have a couple of categories starting from the top to the bottom. The first dash is arbitrary or fanciful. Next dash is suggestive, and then there's an underline under suggestive. And then below that is descriptive and generic. That line is there because all of those things above it, suggestive, arbitrary, or fanciful, are what we call inherently distinctive. So that means that if you go to the USPTO to register the mark, then the examiner won't question it very much as long as there's no one else using that mark in that class of goods or services yet. They'll say, okay, well, that looks like that's distinctive enough. And so we're willing to at least consider giving you registering it for trademark protection. Contrast that with things below it. Like we'll take the lowest level of generic. You're selling cars and you want to just call them cars. You want to brand them as cars. Well, despite, the Pixar movies of that name, but again, that was a movie not selling cars themselves, although I guess the merchandise was, you get the idea. But if you're trying to just sell actual automobiles and you want to just call it cars and develop a brand, you can't do it because it's the generic name for the class of goods or services. We just mean that category of those kinds of things in the world. So if you try to do that, then we don't want other people to not be able to call their cars cars. So you can never get protection for a generic mark. So it's not only not inherently distinctive, you can just never get protection. And there's an interesting class called descriptive, and it kind of describes it. So I have fast cars or even electric cars, which is a big thing now. Interesting, if you go EV, maybe is there some potential protection there, at least by a collective organization, or you have EV charging stations. But holding that aside, just saying electric cars is descriptive. It may still, in fact, be generic for that class of things. But so take the example again, maybe fast cars. It describes the product. We also want to be very careful in allowing people to have exclusive rights to that because other people need those English words to describe their product as well. So we'll only allow for trademark protection of descriptive marks if they've obtained what's called secondary meaning. And that means that in a particular demographic area, a particular consumer marketplace, many of those consumers have come to understand that that's not just descriptive of any old product like that. It's described for a particular kind of product. And then if you can show the examiner that, the examiner's satisfaction, or if it's in litigation later on, if you can convince the court, potentially a jury of that, then you will have trademark protection. But still, lawyers will caution you away from using descriptive marks because it's just so much harder to build that protection in. Now, moving back above the line for suggestive and arbitrary or fanciful, suggestion is where it doesn't just directly describe the product, but it does kind of give a hint. It only takes one sort of mental step away to think about it. So things like copper tone skin, sun lotion that used to be sold. And so, you have to think about it if you're like, oh, I guess it will give me a copper tone to my skin, and I guess I want that. So that sort of thing is suggestive. And so in that case, then other people don't necessarily need to use that to describe their product. And so we will allow you then to register that. That's a fairly strong kind of mark. And then arbitrary or fanciful are at the top of the heap. They're a little bit different. Arbitrary means it's a regular English word, but is not normally associated with that. So when Apple started branding itself, making computers under the term Apple, that seemed fairly arbitrary. And so that's a good way to go. That's a powerful kind of potential trademark. Fanciful is where you make up the word. It's a coined word, like things like Kodak. And so in that case, then again, very strong because it doesn't stand for anything in the world right now. It's a made up word. Now, be careful, though, because when we give branding advice to startups, because you're early in the company and it's a good time to think about your mark, not before you invest a lot of time and money into it. But the higher the distinctiveness of the mark, especially if it's fanciful, you have to be careful because you can actually fall all the way down to the generic level if you're innovating in a new class of goods or services that no one else had before and no one knows what to call it. So that's the problem when you'll see ads for, the famous one recently for Velcro, and the company's lawyers actually got on to this song and dance routine about not calling it Velcro in a generic sense, but calling it like hook and loop connector or something like that. Lots of things that we think of as plain English words now, we're not. Escalator, cellophane, aspirin, were actually made up brand names. But because there was no other name for that class of goods or services, then they suffered the fate of genericide. And so in genericide, then your market, like it sounds, essentially been killed. And so now you have no protection. You've kind of given it up to the whole marketplace. So again, companies, Google doesn't want you to say, I'm going to Google something. Even though as an entrepreneur, you say, gee, that's the best thing. Everyone's using my name now. But again, beware of genericide. Okay, so a few things beyond the traditional sense of using marks to enforce that you are selling a particular good or service. Then there's also the Trademark Dilution Act, which means you can go against people, even if they're not directly infringing in the conventional sense of your mark, but if they're doing things to weaken it. So if you did have a made up word like Kodak, and then other people start using that in a way that makes it unclear that this mark now only stands for one thing in the world, or at least one thing in that class of goods or services, you could have a blurring action. Or tarnishment is where you take something that often we use an example of a very wholesome family brand kind of thing, and then somebody starts doing things with it to make it look like it's associated with not so wholesome family-oriented things. And that would be so-called tarnishment. There was a lot of stuff, and we've kind of figured it out now, but there's still a lot of conflict and tension in when you want to have a domain name, a URL, and you want to then use your trademark that you have, and you find, lo and behold, somebody already has registered that URL with your trademark in it. So then there's ways to try to go about trying to remedy that situation. Okay, so now on the defense side, so you're the trademark holder, you try to then enforce this. And then the defense on the other side that's using your mark can say, no, it's generic. Everyone's using it just for the name of the class of goods and services. So you can't enforce it against me. Functionality, as I mentioned before, well, it's an element of the product. So think about a visual element to a product. And now it really is a functional part of the product. So you can't go after me for that because there's no trademark at all. Abandonment, you had the mark, but you stopped using it. And you've let it go for so many years that no one expects that it's a trademark anymore. So you've abandoned it and I can use it now. Nominative use, even though a lot of times we think that, oh my gosh, if I ever mention the words like Coca-Cola, I have to put the trademark symbol or something and show that I understand it's a trademark. Not so if you're just using it to talk about Coca-Cola, either the company or the product. As long as you're not using it in an advertising sense, then you don't need to worry about infringing, or you don't need to put the symbol and stuff on it. Parody is a kind of fair use, like Professor A. Stars talked about fair use and copyright. Parody here is where you're making fun of the brand. You can't just be using the brand to do a general social satire. It really needs to be, sort of making fun of the brand itself. And then if you do that, then that use would not be infringing. Okay, so as I mentioned, to develop your rights at the state level, you just have to start using it on goods or service in commerce, or registration if the state has that. But note that when you have state rights, they're only enforceable in that particular state. That's why people like to try to get the federal rights. You can, even if you're not using it in commerce yet, you can try to do a so-called intent to use application. And then you have a bit of a period through which you have to then show that you're using it to keep that registration going. Also, as I mentioned, that you are registering your mark in a particular class of goods or services, computer hardware or construction equipment or something. You have to identify that category. And the only exception to that is when certain brand names become so famous, like Disney or something like that, or even Apple, then they become so-called famous marks and will actually allow you to enforce them outside of your normal goods or services, because you're such a big company doing so many lines of goods or services that the public wouldn't be surprised, or they might expect if they saw Disney on something, even if it was an automobile, they might think, oh, I guess Disney's co-branding with cars now or something. So then famous marks can have even more power than that. There used to be a lot more restriction on both registering and enforcing so-called immoral, scandalous, or disparaging marks, but a number of key cases in the past 10 years or so have really cut that back. So while it's still, the doctrine's still kind of out there, it's much weaker at this point. You get a 10-year term and you can keep renewing it for another 10-year term, pretty much indefinitely. So it's a great protection in that way. You must so-called police the mark, which I sometimes people seem to be complaining that a trademark owner is being too aggressive. But if it doesn't look like they're actually enforcing their mark, if they're not policing it, then it looks like they've abandoned it and then they've lost it. No assignments in gross or naked licensing. Both those sound a lot more intriguing than they actually are. Assignment in gross just means you can't just sell the mark to somebody else without selling the business as well. So if you developed a cool brand, no, you can't actually just sell it to somebody else. It has to go with the business that you're doing. Similar with naked licenses, you can't just license somebody to use the mark without being somehow associated with something that you're doing.